Good morning, and thank you for joining us for the third session in our Bid Protest from All Angles series. Today, our expert instructor, Jeff of GT Law, will be walking us through corrective action and bid protest. What do we do now? This session will run from 10 to 11:30 Eastern. Just a few housekeeping notes before we begin. Recording and your certificate of completion will be emailed out within 2 business days. To access this, or no, that will be emailed, sorry. But for any other certificates, you'll need to complete the password survey on the PCI website under My Certificates and Courses. Passwords will be shared via polls during today's session. Please write them down when they appear. There will be 3 throughout today's session. If you are looking to follow along with the slides, they are available for download in the materials section, which you can follow along or reference later. It looks like a paper with a paper clip, and it should have the PDF version right there. If you have questions during today's session, feel free to enter them in the questions box at any time. It's a chat box with a question mark in it. We'll be monitoring it in real time, so if you have any technical issues, I can address them directly, or if you have any questions related to today's content, Jeff can answer it today as well. If you need help with passwords or certificates, email Josh Pina at publiccontractinginstitute.com, and for CLE related questions, contact Joshua Lee, that's JOSHUALY at publiccontractinginstitute.com. And with that, I will turn it over to you, Jeff.
All right, thanks very much. For those of you who joined, I guess it's 2 weeks ago now, I apologize sincerely for the technical errors. I had a lot of technical troubles getting kicked off, and then I think the broadcast actually ended early because of some technical issues on the other side. So sincere apologies for that. I'll be talking to PCI and hopefully re-recording that episode so that people can get access to that. That's part 2 about post-award protests. As I mentioned there, those are the protests that most people think about. In some ways, in my own view, those are the least valuable form of protest. Pre-award bid protest has the highest likelihood of you actually changing the ground rules of the procurement so that you can get a real chance at winning the contract. Post-award, they're successful. Again, corrective action and GO bid protests, or the effectiveness rate, which includes corrective action sustains, is about 50%. And a lot of what we're going to talk about today is that probably the most complex issue that arises in a standard bid protest, which is corrective action occurs. Now what do we do? Because it puts you in this weird situation where you're sort of both post-award by definition, but then also pre-award, and you got to think about how that affects your timeliness rules. So hopefully what you see today will be helpful to you in navigating that. I will rely upon some of the things I've said in the prior broadcasts, but if you have questions at any time, just go ahead and put them into the chat, and I will answer them as they come up. Without further ado, let's get into the show. So the fundamental bid protest concerns remain the same. You've seen this slide in other presentations. Jurisdiction matters. Where are we going to go? Standing matters. Are you somebody who has the right to bring a bid protest? And remember, the measure of that is, do you have a direct economic interest in the outcome of the procurement? And that's slightly different in a pre-award context where we don't know exactly how the thing's going to go, and a post-award context where we know what happened the first time around. Timeliness. The timeliness rules are very strict, especially at GAO, and we've talked about those. Prejudice, you have to demonstrate not only that there was a problem, that there was a defect in the procurement process, that's a successful protest, but in order to get relief, you have to demonstrate that you individually were prejudiced, not somebody else. And in most cases, one of the things that people care about is getting that stay of performance so that the agency does not move forward with a contract that you have protested. These fundamental bid protest concerns, they remain the same, but how they affect us is going to matter in the corrective action context. Corrective action just being the agency has accepted a protest, they've taken corrective action, to go fix some of the errors that have been highlighted, or at least not to defend the award that was made. And now we're in this limbo where there's not a lot of prescriptive rules about what the agency has to say to us or what we have to do in order to make sure we're observing our rights. So it's a time for contractors, especially, to be vigilant. And when I say contractors, I mean both the company or companies that have filed the protest that succeeded, but also the original awardee. Their interests are really going to matter here, and the shape of corrective action is obviously going to matter to them. So there's a lot of different interests that show up in these corrective action protests. I've put up here, a hypo to kick us off. It's going to be a tough hypo, and I'm going to ask you on the next slide to give me your answer in the question box. It's real tough, and I would not expect that most people would get this right. But hopefully, after we go through today's training, you'll have better tools to answer it. So this is a hypo where Globotech is going after a $100 million IT support services contract with the Department of IT, a made-up agency. That agency made an award on a best value basis to IT gurus. So Globotech wants to protest this $100 million award to IT gurus. During the debrief, Globotech learned that its price was $10 million lower than IT Gurus, but IT Gurus was rated higher than them, both under Factor 1 technical and Factor 2 past performance. So there should have been a best value trade-off here to justify giving it to IT Gurus despite Globotech's lower price. Globotech files a bid protest at the GAO, alleging that the agency engaged in misleading discussions and conducted a flawed evaluation under both factors 1 and 2. So those are good protest grounds because if you can fix the evaluation of factor 1 and factor 2, you can get in the winner's circle. Also, alleging misleading discussions, if you have a good basis to do that, that's great because it should prompt the agency to re-engage with you in another round of discussions, and you can fix whatever the problems were in factor 1 at least, and maybe in factor 2 past performance as well, although the agency's obligation to engage in discussions about factor 2 is pretty non-existent. We may have said this earlier, but it's worth noting here. The only discussions the agency is required to give with respect to past performance is about adverse past performance information to which the offerer has not had an opportunity to respond. What does that mean? It didn't come in as CPARs because of CPARs you've already had a chance to respond. This is like there was an LPQ that somebody filled out. It said bad things about them, bad things about you. You've never had a chance to respond to it. That's the only discussions you're entitled to. So anyway, we got this corrective action. Okay, and I have a question already, but let me get through the slide before I go to that. I'm having a little trouble reading all of its words, so give me a second for that. So after several months of this, Globotech files this bid protest. The agency files a notice of corrective action, and it announces its intent to reevaluate proposals under Factor 1 and make a new award. Now, if I'm Globotech, I filed my protest, that doesn't feel sufficient to me. I've challenged 3 things. I've challenged Factor 1, which you say you're going to reevaluate. That's good. I've challenged Factor 2, past performance, but you don't even make any promises about that. And then I've challenged misleading discussions, and there's no mention of that here. So already as Globotech, I'm switching my mindset from post-award protest to pre-award bid protest thinking. Pre-award bid protest thinking, I've got to be worried, how is the agency's, what are the ground rules of this procurement, this next phase of the procurement, and are they fair to me? Is it a level playing field or one tilted in my favor? And if it's not, you got to be engaged in that pre-award bid protest thinking and thinking about getting on that continuum, which again involves reaching out to the agency, potentially filing a pre-award protest, etc. So after several months, Globotech asks its attorney to check in on the status of corrective action. The agency counsel says that the CO is on track to make a new award decision within the next month. This is shocking to Global Tech because, again, they filed a protest that said they had misleading discussions. How could corrective action that does not engage in discussions ever fix the errors that they've objected to? And this is where we get into the timeliness rules and this need to kind of very aggressively protect your rights in this limbo status after once corrective action is announced. So the Global Tech's president gets troubled by this comment that they're about to make award, asks the CO to clarify whether the agency will engage in new discussions. The CO ignores Global Tech's question and proceeds to re-award the contract to IT Gurus 5 days later. So now Global Tech files a new bid protest at Chiow challenging the agency's completion of corrective action without discussions. That's a pre-award bid protest issue, and the reevaluation of proposals under both Factor 1 and Factor 2. That evaluation, that challenge to the evaluation is a post-award. So I think I said this in an earlier session, sometimes we get ourselves in a situation where we're filing a simultaneous pre-award and post-award bid protest, and that's really the situation here. So I'm going to talk through these options, then I'd love for folks to put their answer in the question box. So when Global Tech protests that new award and they say, I'm challenging the corrective action without discussions, and I'm challenging your reevaluation of Factors 1 and Factor 2, what is GAO going to do? Is it going to dismiss the protest in its entirety? Is it going to dismiss only the protest ground that challenges the completion of corrective action without discussions, that pre-award issue? Is it going to dismiss the protest grounds challenging the reevaluation of Factor 2? Is it going to decide all these protest grounds on their merits? Or is it going to do B and C together? So go ahead and throw your answers in the question box there. And I will try to read this question while we go here.
Do you want me to read that aloud to you, or?
No, I'm trying to get my box wide enough I can see it. There we go. All right, let me go back to the, we got a lot of E's. We got some C's, B's, and E's. Okay, so the majority say it's B and C. They're going to dismiss the protest ground that challenges the completion of corrective action without discussions. That's a pre-award issue, and if you're paying attention, to the timeliness, that's right. That's going to get dismissed because it's a pre-award issue that was not timely brought, and we'll explain in later slides when it should have been brought. And then C, dismiss the protest grounds challenging the reevaluation of Factor 2. The challenge is to the reevaluation of Factor 2. I think it's likely that GAO will actually resolve the Factor 2 evaluation on the merits because it didn't do it the first time around. But if what the allegation was is, hey, they should have reevaluated Factor 2, which they decided not to do, that would be a pre-award protest. So I think actually the best answer here is B, but it's real difficult to get that one right. And by the way, I don't think 100% of GAO attorneys would give you a consistent answer to that. So it's pretty tough. Speaking of tough, the question that came in says, where can I find the previous corrective actions that have been presented in past corrective action protests? Concern is that, it's tough for experts, maybe including me, to explain how reasonable those are, or what the likelihood of success is. GAO issues hundreds of bid protest decisions a year, and many of them involve corrective action protests. Part of the reason actually that I developed this round of the training is because there's not a clear consensus around it. There's plenty of articles on the topic, but at the end of the day, the basic question of whether or not you can win a bid protest, I go back to one of my slides, which is I don't think it's in this presentation, Every protest is a winner and every protest is a loser. The actual merits of the protest grounds, you really can't know until you file the protest, but you can make an informed decision about whether there is a viable bid protest here. So, all right, let me move on to our next slide. Keep this going. Sorry, resume slideshow. One of the problems is every time I turn my mic on or off or check a questions box, I got to go reactivate my presentation. All right, here we go. What is corrective action? It is the result in nearly half of bid protests. So this comes up all the time, which makes it kind of frustrating that there's not a lot of clear answers. Corrective action gives the protester some form of relief, but it may not be a contract award. In fact, almost never is it a contract award. In a pre-award situation, the corrective action may remove an unduly restrictive term. You succeed in your pre-award protest, or you succeed by convincing the agency to take corrective action from your pre-award bid protest, and they may remove that requirement that you have a DCAA audited accounting system because it's not within your authority, your power to control that. Maybe they do that because it was unduly restrictive and unnecessary to the procurement. In a post-award situation, they're promising to do something like reevaluate proposals. They might promise to engage in discussions. Agencies, after there were a ton of fights over the adequacy of proposed corrective action, they kind of took to this, at least the Air Force and some others took to this thing of saying, we're going to do X, Y, and Z and reserve the right to take any other action we deem necessary. And so by doing that, by promising that they're going to do whatever else is necessary, they kind of avoided these fights that we often get into over, how, the sufficiency of the corrective action. The short answer on a challenge to the corrective action, what its shape is going to be, is it's very hard to win, and we'll see that in some later slides. The GAO protective protest effectiveness rate hovers near 50% every year. That's broken up into voluntary corrective action, those 35% of the times, and then 15% of times, which are mandatory. Numbers and corrective action options are similar at the Court of Federal Claims, but we don't have any data to kind of measure that. There is a question here that asks, how many rounds or iterations of corrective action have I experienced for a single protest? There's a famous case, and I can't remember its name. It's like DZSP. It's a joint venture that was doing some work in Guam, some kind of like infrastructure work in Guam. That thing got protested like 4 times, and eventually the corrective action in one of those protests, it was maybe the 4th major protest of this, was the decision said the agency's requirements had changed so materially over the life of this bid protest that they actually had to issue a new solicitation. And so I think I've experienced at least 3 or 4 rounds of bid protests, but there have certainly been at least that many in various bid protests. What are corrective action protests? Any protest that comes after the agency takes corrective action, whether it's voluntary or because GAO or the Court of Federal Claims told them to, is a corrective action protest. As we said, protest victory is not a win, but the agency gets this opportunity to fix any errors. It could still come to the same conclusion at the end of the day. So how do you avoid an empty victory if you are a protester? You protested, you got that corrective action. How do you get that to actually lead to a different outcome? You may need to protest the corrective action, the shape of that corrective action, to obtain meaningful corrective action. And your objective, if you're going to do that, is to shape the corrective action so that it gives you the best chance for award. That is just like pre-award bid protest thinking, right? That's the exact same kind of mindset. If you were the original awardee, how do you preserve your award? Well, you have the exact opposite incentive. You want to keep things the way they are. You may want to actually file a protest to prevent corrective action from resulting in a different award decision. The idea of that protest is going to be stop corrective action altogether, or keep it nice and narrow to reduce the risk of a different outcome. So and both parties, the original protester and the original awardee, have the ability and should be thinking about, is there a corrective action protest that I should be engaged in here? Agencies will take corrective action for various reasons. It's not listed here, but a really practical one is the contracting officer and or the lawyers don't think that they can get the work done to defend a protest. They just don't have the resources or time, and so they will just take corrective action because it's the easy button. That's legitimately a reason why agencies take corrective action. But it also could be because they recognize an error or an oversight in the process that they need to fix. They see some litigation risk here that they want to avoid. They want to correct that record to neutralize the vulnerability from any bid protests, or they need to bolster the record to justify their original and preferred outcome. Those are all factors or considerations that go into the mind of the agency as it's trying to take this decision. And by the way, I've mentioned this before, but it's a good reminder for folks who don't see a ton of bid protests. If an agency is going to take corrective action, it is almost always going to do so before day 30 of the GAO bid protest window. Why is that? Because on day 30, that is when the agency is required to submit its agency report, which includes all the relevant records, documents, but also the agency's memo of law and the contracting officer's statement of facts. As soon as the agency publishes that and the protester starts spending money to read and review it, that's when the clock turns on or the meter turns on, and the protester can recover its costs for any successful bid protest grounds. And so that's why you'll see agencies taking corrective action within 30 days. Typically, it's like on that day, it's like on day 25 when they're required to say, hey, I'm going to give you these documents, the 5-day letter. That's oftentimes when it happens. Okay, so the agency files this notice of corrective action. What are you going to do about it? Well, you got to look at it. What is it promising to do? Are they going to revise the terms of the RFP? If I'm a protester, I love that, because as soon as the agency revises the terms of the RFP, it means by definition, I get an opportunity to update my proposal, or at least the parts of it that the agency has changed the RFP for. Will the agency reevaluate? If so, what evaluation factors will be considered? Again, here we had the agency saying it's going to reevaluate factor 1. It did not say it was going to reevaluate factor 2. If we think that meaningful corrective action would have to reevaluate factor 2, we ought to raise that as a protest ground here. Again, from our hypothetical, we may still get to challenge the outcome of factor 2 because it didn't get resolved in our original protest. But again, at this point, when we're considering this corrective action protest, what we're thinking about is, what do I need to do to fix things? What do I have to do to make this either fair or tilted in my favor? Will the agency permit revised proposals? And if so, will there be any restriction on the scope of proposal revisions? This is critical. I mean, I guess I kind of assumed it in the first answer, will the agency revise the terms? But it's not crazy. It certainly has happened that agencies have revised the terms of the RFP, but not allowed for new proposals. In fact, that is the comment case that we'll be talking about later. But this is what you want to look at. If I'm a protester, again, I want that chance to permit revised proposals, and I want that chance to match where I have problems. If I know that I'm going to lose on factor 1 unless I get a chance to update my proposal, I want the corrective action to include that. Same thing if factor 2 is necessary for me to win. Another question is, does the agency plan to hold discussions? Again, this is following a post-award protest. As part of that post-award protest process, we got a debrief. We filed a protest. We know what things we need to get fixed. And if we get the chance to have discussions with the agency, that will be our opportunity to get them fixed. Will the agency terminate the awarded contract, or will it suspend performance on the awarded contract pending the outcome of corrective action? Agencies got real sneaky about this for a while, and they said, we're just going to suspend performance on the awarded contract. We're going to keep it in place. And once we complete our corrective action and make our new decision about what we're going to do, we're just going to move forward with that. That creates a problem for timeliness, because per the Competition and Contracting Act, timeliness of a bid protest at GAO and at the agency is triggered by the award decision or a debrief of the award decision. And by doing this thing where they're keeping it in place and sometimes not guaranteeing that you're entitled to a debrief, that makes it really complicated. So these are critical issues and questions you need to ask as you're considering, is there something I need to challenge about this corrective action? So the protester, its mindset has to be, what are my chances for award after corrective action is completed? Will this corrective action will this corrective action work out for me, or do I need to file another protest to improve my prospects and to get out something that's unfair about this procurement that's before me? As the intervener, again, you're thinking about the opposite of that. Will corrective action jeopardize my award? Do I need to file a challenge to what has been announced as the planned corrective action that attempts to mitigate the risk of that different outcome? And those are your rights. Let me go to the next slide and then check on my questions here. Is corrective action solely with GAO, or does the Court of Federal Claims also invoke corrective actions? I actually have a case right now at the Court of Federal Claims where the agency has promised to take corrective action. But their corrective action in that case is to say, we're just going to keep going with our current award, but we're going to conduct a new competition that'll be fair and open and whatever, and it'll fix all your worries. My answer to them and to the court, which I'll be making soon, is that's not corrective action. Once I've shown that your award is illegal, it has no basis. It's void ab initio. And if the agency wants to meet those services, they can go out and do another procurement. But that contract is invalid. So we're going to have a fight about that. But the answer to the question before us is, can you get corrective action at the Court of Federal Claims? And the answer is always yes, you do. In fact, it happens a lot. And one of the things DOJ likes to do in those is to tell the judge, hey, judge, this is almost always in a post-award context, hey, judge, we want you to maintain jurisdiction over this case, but we want you to remand it to the agency so that they can take corrective action. And what that almost always ends up doing is it goes back to the agency, they take 6 months or however long it takes, they clean up the record, and they come back with the same record, and now they sort of get to that quicker outcome of defending what they did on a new record. So that's kind of a tool that DOJ likes to use. All right, there's 3 different flavors of corrective action protests, and this is sort of the best attempt I can come up with to explain corrective action protests, because they are so fluid. It matters what happened in the post-award protest that prompted corrective action. It matters what the agency says they're going to do with corrective action. It matters how that affects you and what you need to get done. And so let's break it down into these 3 different areas. You can protest the decision to take corrective action. You can protest the scope of corrective action. So yes, they're taking corrective action. What is it going to look like? What is its shape? And then third, you can challenge the execution of corrective action. Okay, they've promised corrective action of a particular scope. I'm here to challenge its execution. The first 2 of those are essentially pre-award protests. For those, what you're concerned about are the ground rules of the procurement. For the last one, the execution of corrective action, that's really a post-award bid protest issue. So there's different timing and strategic considerations that go into that. And there's a fine line between what is a scope protest. Here are the things that I'm going to include in my corrective action, versus an execution protest. This is how I have conducted the corrective action. And there's very significant implications for timeliness based upon which side of that line you fall on. Okay, I got to go back here. Same slideshow. Okay. Protesting the agency's decision to take corrective action. An awardee may seek to prevent any corrective action if corrective action is voluntary, the awardee can go to either the GAO or the Court of Federal Claims. If they go to GAO, what they're going to hear is that GAO will not object to corrective action, quote, so long as it is appropriate to remedy the concern that caused the agency to take corrective action. That's really critical because it's focused on the agency and what motivated it to take corrective action. As long as they say that that's what they're doing, GAO is going to say, fine by us. Notice that that has nothing to do with what were the grounds of your protest that caused the agency to take corrective action. It's only to remedy the concern that caused the agency to take corrective action. And that decision is not going to be disturbed unless there's a significant abuse of discretion. So you might think, okay, would I be better off at the Court of Federal Claims? And you might want to appeal that decision to the Court of Federal Claims. We've said before that a protest of the Court of Federal Claims is a protest to a different forum. It's not really an appeal of GAO. But in the corrective action protest context, it's pretty close to an appeal. Here, if corrective action is in response to GAO's recommendation, the awardee can go to the Court of Federal Claims to quote unquote appeal GAO's decision. What you're challenging is that the agency's corrective action lacks a rational basis because it is implementing a GAO recommendation that is itself irrational. So again, it's not truly an appeal of GAO's decision. It's a challenge to the agency's decision to follow what is an unreasonable GAO recommendation. So we have the Turner construction case from 2011 in the Federal Circuit that kind of articulates that. There was another case that next year that also made it to the Federal Circuit and said an awardee may attack an agency's reliance upon GAO recommendation, outcome prediction, or even preliminary views expressed by GAO attorney regarding how the protest was resolved. So it doesn't have to be a formal corrective action, as was the case in Turner Construction. It could be, as happened in the SATEC case in 2012, it could be GAO just deciding of its own, or sorry, the agency deciding of its own volition because of something it heard in a hearing that it ought to take corrective action. Again, the timeliness considerations matter here. So if you want to take that challenge to the decision to take corrective action, if you want to challenge that at GAO, there is a 10-day clock triggered by the agency's notice of corrective action. And if you go to the Court of Federal Claims, the blue and gold and comment rules are controlling. And just as a reminder, the blue and gold and comment rules come from our pre-award bid protest thinking module where we talked about those challenges to the ground rules of the procurement. You have to challenge them prior to the close of the bidding process. And that same general rule applies here to the corrective action context. Remember, we really are looking at a pre-award bid protest in this scenario because we're focused on that future procurement. I'll go to the next slide and pick up my questions here. What is my latest question?
While you do that, I am going to put up the first password. Password 1 is up on the screen, and that is Arnold, capital ARNOLD. Again, that's Arnold. Password 1 of 3. Make sure you're writing these down as they appear for the password survey. All right.
All right.
You said you saw the question, right?
Yeah, that's sort of like the prior question. There's a lot in there, and I think it's a little bit too much for me to tackle here. So happy to answer those questions offline if that person wants to ask them again.
I can forward the question to you with their email and everything. Okay.
Yeah, appreciate that. Thanks so much. Mm-hmm. All right, so we've gotten ourselves into another hypothetical here. We got Crane folks who filed a GAO protest that challenged the U.S. Army Corps of Engineers award of contracts for road improvements near the border crossing in McAllen, Texas. The Operators Corp was one of the 3 awardees of what had become a highly political procurement. Despite Crane folks raising 10 protest claims against all 3 awardees, GAO recommended that the Army Corps take corrective action based upon just one apparent error. The CO had relied upon unsworn statements from another awardee CEO when conducting their OCI investigation. What recourse does operators have? Could they request GAO's reconsideration? Could they challenge corrective action at GAO or the Court of Federal Claims, or all of the above? So again, looking at this, the Crane folks filed its protest. Operators as an awardee. Operators thinks that it's unreasonable for the agency, the Army Corps here, to take corrective action based upon this one unsworn statement that it relied upon in its OCI investigation. Maybe it's more than one. So they can request GAO's reconsideration. I would say, if I haven't said this in prior modules, it is, you might as well just light your money on fire rather than request GAO's reconsideration. They will not change their decision, period. The standard that they use is that you have to identify, I actually can't even remember the standard they use because it never works. You're never going, you have the right to request GAO's reconsideration. You will always be denied. I think literally once in the past 20 years, I've seen a GAO reconsideration work, and GAO gets over 2,000 protests a year. You can challenge corrective action at GAO, so you file that corrective action protest at GAO, just like we said on the prior slide, or you can do it at the Court of Federal Claims. So you have all of those rights. It's just that the first of those is pretty much useless. Okay, back here, resume slideshow. All right, so let's look at an actual case from the Federal Circuit and talk about, or it's a Court of Federal Claims case that talks about this kind of a scenario. PDS Consultants filed a GAO protest challenging the VA award of a contract to supply eyeglasses. In response to the protest, the VA notified GAO that it would take voluntary corrective action by canceling that award and amending the solicitation to clarify this latent ambiguity in the solicitation and make a new award decision after proposal revision. So again, PDS Consultant says, hey, there's a latent ambiguity in your procurement. The agency says, yeah, that's right. It was a latent ambiguity. Remember, a patent versus latent. Patent ambiguity is one that's obvious. A latent ambiguity is one that's hidden. And you know, if there's this sort of hidden ambiguity in a solicitation, it is right to fix that so that people can compete intelligently against the agency's actual requirements. So that's what the agency says it wants to do here, VA. But Superior, the original awardee, protested that decision to take corrective action and sought an injunction from carrying out corrective action and asked that its award be reinstated. Ultimately, the Court of Federal Claims sustained Superior's corrective action protest, finding that there was no actual ambiguity in the solicitation. PDS was not misled by that claimed ambiguity, and therefore there's no reasonable rationale for corrective action. Again, agencies get great deference from both GAO and the Court of Federal Claims. There are very rare situations where either GAO or the court will step in to say your discretion in what you want to do in corrective action is inappropriate. But this is one of them. It said, hey, there's no reason to take corrective action. There was no real ambiguity there. All right, so we can also protest the scope of corrective action. So remember, we can protest the decision, the scope, or the execution. Protest challenging the agency's corrective action on the basis that it improperly alters or fails to alter the ground rules for the competition, that is a scope challenge. So we're saying either you have or you have failed to fix the ground rules here. It's analogous to a pre-award protest challenge to the terms of solicitation, but scope challenges are not necessarily limited to the four corners of the solicitation. So you might be able to say here, look, there was a defect that was not necessarily in the solicitation itself. This is something else that has emerged through the corrective action process that we need to go get fixed. A scope challenge objects to what the agency intends to evaluate as opposed to how the reevaluation is executed. And again, that's sort of that distinction between a pre-award concern, what are the ground rules, what the agency intends to reevaluate, versus the post-award, how they reevaluate it. And the question is the corrective action too narrow? Is it too broad? That's sort of the crux of a corrective action protest. The awardee is typically going to say, hey, that corrective action is way too broad. You're doing something you don't need to do. And they're saying that because that broader corrective action may jeopardize their award. If you are the unsuccessful offerer who brought your successful protest, what you're going to say is that corrective action is too narrow. You're not taking corrective action that's broad enough to fix the problem that I've brought to you. And again, in looking at that scope question, agencies have broad discretion. It doesn't need to be narrowly tailored to the defect it's intended to fix. So not only is it not, as we said earlier, not defined by your protest grounds, but rather the agency's understanding of the defect it needs to fix, it's also not limited to that defect it needs to fix. They are allowed to take broader corrective action if it would enhance the procurement in some way. And so that was the outcome in the Dell Federal case at the Federal Circuit. And we've also seen decisions like that, like the 360 IT case from from GAO. They are highly deferential to what the agency wants to do in a corrective action protest. And in some sense, this makes sense, right? The rules are set up to say, if what you are worried about are the ground rules of the procurement, you have to file a pre-award protest. Now, in a corrective action situation, I've said several times today, we actually find ourselves back in the pre-award scenario. But what you can't do now that you're sort of pre-award again is challenge things that were already in that original procurement. Your time to complain about the defects in the original solicitation are long since passed. And in most cases, neither GAO or the court is going to allow you to attack things that are already in the contract or already in the solicitation in this corrective action scenario. What you can do, though, is say, look, it was latent. It wasn't clear from the original solicitation that this was a problem. We only were alerted to the presence of this problem by the debrief and our post-award protest. That's how this thing came to light, and that's why you now have to fix it. You have to cabinet in that way in order to get either GAO or the Court of Federal Claims to think about it. All right. Those just talk a little bit more about the cases that are cited above. Timeliness. The protest due date is going to depend on whether revised proposals are requested. So has the agency thrust us back into the GAO rules on timeliness by announcing a deadline for revised proposals? If revised proposals are requested, a protest is due prior to the deadline set for revised proposals. That comes from the GAO's rules, which actually were changed back in 2018, kind of based on the comment case. And the blue and gold thing, it says, before blue and gold / comment, if there's a new deadline, that becomes your time to file a pre-award protest of essentially that corrective action. If revised proposals are not permitted, at GAO, you have to file your protest within 10 days of when you learn of the improper corrective action. And at Court of Federal Claims, it must be filed prior to award, comment. So again, those are the two, and really it's, prior to award, that's a comment case. So it's a little bit more lenient at the Court of Federal Claims. You might find yourself, back to kind of some considerations we talked about previously about jurisdiction. You cannot take a task order bid protest to the Court of Federal Claims. That's off the table. But if you have the right to go to either GAO or the Court of Federal Claims, this is one of those scenarios where you may have to go to the court if you miss your deadline, that 10-day deadline that shows up in that case there. And I've mentioned this before. Anytime corrective action happens, that should immediately flip you over into thinking about pre-award bid protest thinking. That's the mindset that you have to get into, whether you are the protester who's just secured a victory of sorts, or you are the awardee who's now worried about whether you're going to get to keep this thing. You got to be engaged in pre-award bid protest thinking. And that takes us back to that idea from the comment case In the absence of a waiver rule, a contractor with knowledge of a solicitation defect could stay silent. If it loses to another bidder, it can come forward with a defect and restart the bidding process. This gets back to maybe one of the earlier questions about how many rounds of bid protests have you seen. What this rule is intended to do is to say, hey, if what you're challenging is something about the ground rules of the procurement, just like the standard pre-award bid protest rule, you've got to file that before you know what the outcome is. And that comes straight from the Comey case. All right, I don't see any current questions, so I'll keep on trucking. We've talked about the decision. We can protest this decision to take corrective action. We can protest the scope of corrective action or its shape. And then we can protest the execution of corrective action. That's a post-award protest that challenges the outcome of that new evaluation award decision. It looks a lot like a standard post-award bid protest, but the focus is typically going to be on whether the agency has adequately addressed the error identified in the initial protest. And again, remember, it's not so much what was in your protest as what the agency decided to fix from your protest. The agency generally gets a clean slate to defend its new award decision. So if it is truly a challenge to the execution of corrective action, the normal timeliness rules for post-award protests are going to apply. At the GAO, you get 10 days from the award decision, sort of the new award decision, or 5 days after a debrief if you get one of those. And at the Court of Federal Claims, there's no strict timeline, but if you take longer than a month or two, you'll probably start hearing the Department of Justice trying to get the case dismissed on the latches doctrine that says, hey, we're too far down the road, you can't bring this complaint now. You are entitled to another debrief of the new award decision. So remember I said earlier today that there was all this games playing by, we're just going to keep the original award in place, and then we will announce our plans in the future. By adding that assertion, most post-award, most corrective action protests, which is to say those initial corrective action protests about the decision or scope to take corrective action, if you bring it right away at GAO and say their promised corrective action is inadequate because, and you set that out, a lot of times that is not going to succeed because GAO, especially again if you're at GAO, they're going to say, as long as the agency promises to make a new award decision, that's all that matters. We don't care how they get there because you will have another chance to file your post-award bid protest when they get there. All we care about is that they promise to make a new award decision. But the one thing that you can say, this is a very important point here, is if what the agency announces makes no promise that they are actually going to announce a new award decision. If you don't see magic words about new award decision, you may want to consider filing a corrective action protest that at least gets them to promise they're going to do that, because then that makes clear that you will have the trigger of the SICA stay that's offered to you by the Competition and Contracting Act. All right, so interesting question comes in. With the Chevron doctrine gone, do you think the deference given to the agencies would change in these bid protest cases? I haven't thought about that. My just right off the cuff answer though is it is unlikely to change significantly for this reason. The agency's determination of its needs and how to best meet them is entitled to great discretion. And I don't think that has any link really to Chevron. That is really an agency deciding how it's going to meet its needs. And I think, frankly, the current administration and the current Supreme Court would really favor deference to agencies or administrative entities deciding how they're going to meet their needs. It's really the question, the Chevron doctrine gets in the question of their interpretation of the regulations or things like that. So that might affect the outcome of bid protest, but not this specific question about the depth and breadth of the corrective action that's promised. All right, but I'd be happy to enter into a debate with somebody who thinks differently. It's an interesting question for sure. Are you premature? Or are you too late? That question, I mean, in a single day, you can go from you're too early to file your protest to you're too late to file your protest. And so that's why this corrective action period is so critical. You've got to be thinking about, what are my timeliness rules? If you are challenging the scope or execution, I guess maybe we would say if you're challenging the decision and scope or the execution, whichever side of that line you fall on defines your timeliness rules. A pre-award protest, so in the corrective action context, one that's a protest to the decision or the decision of scope is premature if what you're really saying is you're going to give the award to somebody else. You're challenging the outcome of the protective or the corrective action. Protests that anticipate prejudicial agency action are premature. Now, a post-award protest is untimely if it is really a challenge to the scope of the corrective action. So you wait, you let the agency do what it's going to do, they make a new award decision and you lose again, or maybe you're the awardee and you lose, you're the original awardee and now you've lost, and you're like, oh, I want to challenge this. You're untimely if what you're really challenging is the scope of the corrective action that the agency promised to carry out. If that's what your concern is, it's a pre-award bid protest and it has to be brought either prior to the time set for receipt of proposals if there is one, time set for receipt of updated proposals if there is one, or at GAO 10 days after, within 10 days of when you knew that the corrective action was not going to do what you thought it needed to do. Both the GAO and the Court of Federal Claims have kind of adopted this construct of scope versus execution in evaluating timeliness. But that line is murky, and it's not always clear what the answer is going to be. And I say this a lot of times: if you don't know, then file your protest. It's better to be premature than late. It is better to be premature with your bid protest than too late. If you're premature and GAO tells you, sorry, you're premature to bring this, well, you know that you're not untimely, i.e. late to bring it, right? So another question came in, between GAO and the Court of Federal Claims, which venue tends to give more discretion to the agency? That is a very complicated question. I think it really comes down to the individual judges at the Court of Federal Claims and the individual, I don't know, they're called GAO attorneys. I mean, that's all we call them. They're essentially administrative law judges, though. It really does come down to those individuals' predilections, but on the whole, I would say that the Court of Federal Claims used to be much more deferential to agency decisions, and the GAO was less differential. But in the time that I've been doing this in the last 17 years, I think that has flipped. I think now the GAO is worried that it will lose its legislative mandate to do what it does in evaluating bid protests. I think it is actually worried that that's going to go away. And so I think it's being more deferential as a result. And I think that the judges, there are many, many new judges of the Court of Federal Claims, both new Trump appointed judges and new Biden appointed judges. And they are much more willing to call into question agency action. And so I think probably nowadays you get more deference from GAO than from the Court of Federal Claims. But again, it is case by case, and it varies truly depending upon the on who's your judge, who's hearing your case. When to protest discussions. This is one that comes up a lot in the context of corrective action protests, because it's through that protest process that you find out, hey, there's been some kind of problem here that needs to get fixed, and the only way to fix that is through discussions. So the appropriate timing of a protest depends upon whether the agency has left open the possibility that discussions may occur. So we list a bunch of different cases there, but American Canine is a good one, where the agency did not clearly announce the ground rules of the corrective action and did not specifically indicate that no further discussions would be conducted. Then a post-award protest that says, hey, you should have had discussions was timely. It's really where the agency has said, I'm not going to give you discussions. That's when you have this obligation. Now, again, see my earlier rule that says you might as well be premature, right? You'll know that you're timely if you file a premature protest, and so that's the safer path to take. Here's a list and some cases that show common corrective action protest issues. So as I tried to point out before, corrective action is not objectionable even if it does not address all of the issues raised by the protester. The protest is in some ways irrelevant. It's really the defect that the agency is trying to correct through its corrective action that matters. An agency may take corrective measures beyond GAO's recommendation to address the underlying improprieties. So again, even though GAO has recommended, because GAO doesn't order anybody to do anything, they recommend things to agencies. If GAO has recommended that an agency do something, the agency can do more than that. Now, again, sometimes you can challenge that because what GAO has recommended is unreasonable, and so whatever you do to follow it, including going above and beyond it, is improper. That is a good thing. That is potentially protestable. The fact that the awardee's price has been revealed is usually not a basis to object to corrective action that permits revised pricing. This is a huge one. If you're intervening to defend an award and the agency says, we're going to take corrective action and we're going to allow new pricing, that is potentially fatal to your chance to keep this award that you've won. Your price, by definition, has been announced to the awardees, to the unsuccessful offers, and now they all get a chance to lower their price to come in and beat you. It feels unfair, but the case law says very clearly that agencies can decide to do that. Now, the agency can also decide that it would be unfair to allow revised pricing, and that's within their discretion. So this is where we get into that idea of pre-award bid protest thinking and understanding whichever decision the agency decides to make, that it will accept revised pricing or that it won't, is going to get great discretion. And so you may want to put yourself in the position, again, if you're the awardee here, of saying, I want to talk to the agency and convince them not to accept revised pricing. And so one way to do that is to file a pre-award agency level protest that says, here's a bunch of cases from GAO which make the point that it is permissible and appropriate for an agency not to accept revised pricing, where to do so would be prejudicial to the original awardee because it's unfair that their pricing has been revealed. So that is a tool that we've used in the past and used successfully to convince an agency, hey, you shouldn't reopen pricing. That would be unfair. The agencies may reasonably decide to limit the scope of proposal revision. So not only could they decide not to allow revised pricing, they might also say, there's 3 evaluation factors. We're only going to allow offerers to submit revised proposals for factor 2. Factor 1 and factor 3, no changes allowed. You can challenge that, but agencies have a discretion to limit their corrective action in that way. All right.
I can go ahead and put the second password up now. Password 2 is up on the screen, and that is Gerald, capital Gerald, Gerald. Again, that's the second password of 3. Make sure you're writing these down.
All right, we got about 30 minutes left. I'm happy to answer questions as we go. And so let me real quick look at the next question. Is it your experience that contractor protest attorneys advise clients to switch to one form or another based upon the GAO attorney or the Court of Federal Claims judge? Short answer is yes. Again, assuming that you have the ability to decide what forum you're going to go to, because there is jurisdiction in both forums. We have made recommendations. Hey, look, you don't want to be in front of, or it's not going to be effective for you to be at GAO because we got attorney X, and in my experience, that person is always going to deny a protest, or they're always going to deny this kind of protest because we've looked at their decisions or whatever. So some of that happens. I would say it's very rare. And the one thing to know is that you can't really go to the Court of Federal Claims and then say, oops, I want to be back at GAO. That's sort of a one-way door. Once you're at the Court of Federal Claims, you're not coming back to GAO. Now, in a corrective action context, it's interesting. So let's say you filed your original protest. Let's say it was one of those sagas, right? You filed at GAO, you lost at GAO, you filed at the Court of Federal Claims, you won at the Court of Federal Claims, or the agency took corrective action, whichever happened. And now we're moving forward with the procurement. You don't have to stay at the Court of Federal Claims unless there was some issue the court retained jurisdiction over. You can file your new protest at GAO, and one of the factors you might consider in making that decision is we don't want to get in front of that. We want a chance to try to get in front of a different judge. That could be one of the reasons. Okay, another question that came in: how may you go about challenging the Court of Federal Claims qualifications so that an appropriate corrective action response don't fail to broaden the scope or the rules, ground rules for the competition? So to challenge, I'm not sure I understand the exact question, but at the end of the day, the bid protest tools that you have to challenge the scope of corrective action are those that we've talked about in this and the prior things. Again, if you're challenging the ground rules of the corrective action, you have to show that it is unfair, it's unduly restrictive, something like that. And really, unfair is not going to win it. It's unreasonable. Is it unreasonable, or is it unduly restrictive? Those are kind of the ways you can establish that something about the corrective action is improper and needs to be fixed. It's unfair, it's unreasonable, it violates law or regulation. Those are kind of your only options. There has been, I would say, steady to increasing use of corrective action. In fact, last year, I think corrective action ticked up pretty markedly. It was a year in which there were far fewer sustained protests because we didn't have the whole CIO SP3 saga where there were hundreds of sustained protests that kind of skewed the numbers. But the sustains were down and the corrective actions were up last year. And I think that's consistent with my experience, which is agencies are very busy. In many cases, in particular this year, the person responsible for conducting that procurement may not be around, or defending that procurement may not be around. And so it becomes one of those resource issues where the agency says, hey, I'm going to take corrective action rather than defend this because I just don't have either the manpower to get it done, or the people who could do it have left the building. The case law concerning timing still feels somewhat muddled. Again, I've tried to demonstrate here that if what you're challenging is the scope of corrective action, what you promise to do and what its contours are, versus I'm protesting the actual execution of the corrective action, that line can get a little bit muddled, and the case law reflects that. Until 2018, there was a pretty good bet that you could go to the Court of Federal Claims and find a sympathetic judge who would say, this corrective action does not make sense. It is in no way related to the issues that were in the protest, or it is related to issues in the protest, but it doesn't go far enough. It doesn't correct the defects that have been raised. Judges used to say that quite a bit. In fact, Judge Wheeler, who got overturned in the Dell Federal case, was probably one of the best judges to be in front of if that's the outcome you're trying to get. But the Federal Circuit said in Dell Federal, which I think was 2018, no, it's got to be deferential. The courts do not disturb agencies' determinations about how they're going to define and best meet their needs. And again, there is a distinction between that and your typical Chevron case, which is asking a question about whether and how the agency is following. Sorry, I lost my thought there. Whether and how the agency is following its regulations or interpreting its regulations. All right. Now, I'm going to go back here and click again. Seek a stake considerations. So again, this harkens back to that slide all the way at the beginning, jurisdiction, standing, all those kind of things. Seek a stay. In trying to understand how you're going to get your seek a stay, if that's one of the things you're looking for, you got to start with the rules and the regulations, and those rules in part include that case law that we've talked about, that pre-award protest case law we talked about way back in the first session, Blue and Gold and Comint, and the cases that talk about, if you have a challenge to the ground rules, you got to bring it prior to the close of the bidding process. You also need to think about protest grounds individually. If you're trying to get a seek a stay, the seek a stay trigger may be different depending upon the specific protest ground that you're talking about. Because again, as I've said earlier today, sometimes we're filing a pre-award and a post-award protest at the same time. And those are governed by two completely separate rules, both at GAO, where for pre-award protest issues, you're under 4 CFR 21.2A1, or post-award issues for CFR 21.2A2. And similarly, at the Court of Federal Claims, the case law will distinguish. If it's a pre-award issue, it's got that timeliness set of rules. If it's post-award, it's got a different set. And when in doubt, be premature. Of course, bid protest decisions have to be guided by more than just the case law, because in some ways, as I think today's discussion reflects, the case law can be a little bit hard to figure out, and it can be dependent upon the GAO attorney or the Court of Federal Claims judge that you're before. I mean, that it just ends up mattering how they kind of apply the law to your facts, or apply the bid protest case law to your facts. So other practical considerations that come up is, as the awardee, do you protest and risk upsetting the customer, or are you so confident in a reaward that you're happy not to upset the apple cart? If corrective action does destroy the common interest between agency and the original awardee. So I don't think this is a topic we talked about much, but a lot of times it does not make sense to file a post-award bid protest. There might be strategic or business reasons that people want to do it. But if your goal is to actually change the outcome of procurement, a post-award bid protest has a very small likelihood of actually meeting that goal. However, what ends up happening is in a protest, once the protest is filed, the awardee can have their attorneys intervene to help the agency defend the award. And I recommend that people do that 100% of the time that their awards are protested. Why do I recommend that? The agency is not as capable, likely, as you are of devoting resources, of carving off and devoting resources to defending that award. They certainly don't have the same vested interest in doing it as you do. And so for that reason alone, it makes sense for you to intervene. Also, because that is true, if you don't intervene to help the agency out, I have actually seen circumstances where the awardee ended up flipping strictly because The original awardee did not intervene to defend the award, and the agency said, well, if you don't care about it, I don't care about it. That's obviously not the way it's supposed to work, but that's a reality. If you want to protect your award, you have to intervene to do so. And you have to do it quickly because the agency only has those 30 days before they start, before they have to make that agency report and begin incurring liability for protest costs that they lose. And so very early on in the process, if you're the awardee, you want to get in there and you want to help the agency to understand this is a winnable protest. This is in order, it's a losing protest. It's one that we can defend against, and I will help you. And when you do that, you oftentimes communicate awardee to agency under common interest. So just like you have the attorney-client privilege, the common interest privilege exists to say that those communications between agency and awardee may be privileged from discovery. However, as we saw in the Peraton case, a GAO decision from 2020, as soon as that agency announces corrective action, there is no longer a common interest between the original awardee and the government. And so any communications you have after that trying to influence the agency may be discoverable. By the way, that is why when I talked about it earlier and being an awardee in that situation, one of the things you might consider doing is filing an agency level pre-award protest. That'll be protected by whatever rules apply to the discovery of agency level pre-award protests rather than just your strict communications back and forth to the agency. Other practical considerations. Does the original awardee have standing in a challenge to the corrective action? That is going to depend a little bit on the circumstance. So if there's a multiple award IDIQ and Acme gets one of the awards and Delta files a protest and the agency says, I'm going to take corrective action, I'm going to keep my original awardees, I'm going to consider adding Delta, you may not have standing to challenge that corrective action because you are an awardee. And so that's one unique circumstance that has to be considered. And then you have to think about other practical considerations. How does corrective action affect your calendar? There's going to be exercise of options or extensions. There may need to be a bridge contract. The agency's patience may run out. And so you got to think about those practical considerations when you are going through the protest process or when you're in this corrective action sort of posture. Graduating from size status, that's another consideration. However, the rules are pretty clear that these are the SBA rules. As long as the agency keeps that original solicitation number, they can modify it as much as they want to. As long as it's that original solicitation number, you're small, so long as you were small at the time you submitted your initial proposal that included pricing. So that's a very important thing to have in mind. If you're a small business, you won a contract, you're no longer a small business, and the agency is going to go into corrective action, you absolutely do not want them to cancel and resolicit. What you want them to do is to modify the solicitation and accept, if necessary, accept revised proposals, because you may not be a small business eligible if they do it the other way around. All right. So we're back to our hypothetical with Globotech. So let's say that GAO dismisses Globotech's untimely argument that the agency failed to engage in discussions as part of corrective action. Let's also say that GAO denied Globotech's protest challenging the evaluation under Factor 1 technical, but GAO sustained Globotech's challenge to the evaluation under Factor 2 past performance and recommends that the agency either go reevaluate Factor 2 in accordance with the terms of the RFP or revise the RFP to reflect the agency's needs. Then the agency goes and amends the RFP's evaluation criteria to eliminate Factor 2 past performance and allows offers to submit revised proposals by July 1st. Globotech is outraged It appears the agency is attempting to eliminate Globotech's clear past performance advantage so that it can allow IT gurus to undercut Globotech's price advantage. So they are furious about this. What can they do? All right, so let's use the question box again, please, to submit our answers to this. What would you do if you're Globotech in this situation? You won the original, you filed a protest, you got corrective action. That corrective action actually sustained, was protested again, and they actually sustained part of that. And now we're going to sort of round 3 of this procurement, and the agency says, well, we're just going to cut out factor 2. We don't care about that anymore. And you think that that's really harmful to you. What are you going to do? I'm not seeing any answers yet. So let me talk through them a little bit while we wait for answers to roll in. Globotech can protest the agency's corrective action anytime prior to award at GAO or the Court of Federal Claims. Globotech may protest the agency's corrective action anytime prior to award at the Court of Federal Claims, but it must protest at GAO prior to the July 1st deadline for revised proposals. Or Globotech must protest the agency's corrective action prior to the July 1st deadline for revised proposals at GAO or the Court of Federal Claims. Or D, if Globotech wants to challenge the agency's evaluation under Factor 1, it can raise that issue in a post-award protest at the Court of Federal Claims if the award goes to IT gurus again. Or is it C and D together? This is unbelievably complicated question. I can't believe I put this in here. It's completely unfair, but everybody's given answers and I like it. So first, let's just talk about C for a second. Globotech must protest the agency's corrective action prior to the July 1st deadline for revised proposals at GAO and the Court of Federal Claims. Let's go back to that prior slide and talk through that for just a second. Oops. Slideshow. The agency amends the RFP's evaluation criteria to eliminate Factor 2 and allows offerers to submit revised price proposals by July 1st. So they're not even allowing updates to Factor 1 where you've already lost because GAO denied the protest challenging the evaluation of Factor 1. So Globotech must protest the agency's corrective action prior to the July 1st deadline for revised proposals at GAO and the Court of Federal Claims. That is true. That is the comment rule, and that is GAO's equivalent rule that showed up because of the comment case. And what they say are, you must, where the agency has set a new time for receipt of proposals, you must file your protest prior to the new time set for receipt of proposals, period. If there is no time set, then you have to challenge it within 10 days at GAO or challenge it prior to award at the Court of Federal Claims. But we got a deadline. That becomes our deadline for both. So C is definitely part of the right answer. The question is D also part of the right answer so that C could be correct? Sorry, so that E could be correct. If Globotech wants to challenge the agency's evaluation under Factor 1, it can raise that issue in a post-award protest at the Court of Federal Claims if the award goes to IT gurus again. Let's go again back to the prior slide so I can explain why that might be a good answer for us. We're at the GAO, right? So all these prior protests have been at GAO. And so if we come back here and we look at D, if Globotech wants to challenge the agency's evaluation under Factor 1, it can raise that issue in a post-award protest at the Court of Federal Claims if the award goes to IT gurus again. Of course it can, because the Court of Federal Claims is its own body, and you can bring your new protest after a new award decision to the Court of Federal Claims, no problem. So the correct answer is E, which a lot of people got to, and that's impressive because, frankly, I didn't know the answer myself until I talked through it. All right, excellent work on that. We got 10 more minutes left, and I don't think I got a ton of slides, so if you got questions, please put them in there. Yep, I got no more slides, it turns out. We've come to the last slide here. So while I wait for questions to roll in, just let me take a couple seconds to review what we talked about here today. Corrective action bid protests put ourselves in the situation where we are sort of betwixt and between a pre-award and a post-award bid protest. We're in a situation where we've succeeded by challenging the prior award, but that's kind of irrelevant. What matters going forward is, do we need to attack the ground rules, which is either the decision or the scope of the corrective action, or are we going to want to challenge the actual execution of that? That would be a post award. We get ourselves in that space, and you got to be thinking every day about, has something triggered my responsibility to file a bid protest? Is there something that has happened that has caused me to be in a situation where it's now time for me to challenge the ground rules of this procurement? And the way to do that is obviously through a pre-award protest, and that takes us all the way back to pre-award bid protest thinking, which was our first module of this. If we end up wanting to challenge the outcome again, now we're in post-award, which is module 2, and all the considerations that go there. But when we're in this kind of difficult world between that is called corrective action, there's not a lot of clarity, and so you've got to always keep asking that question: is there something that I should be doing to protect my protest rights? Can we get our third and final password?
Yes, I will put that up now. Password 3 is up on the screen, and that is Helga, capital Helga. Again, that's Helga. Make sure you're writing that down for anyone that is seeking credit. That is the third of 3 passwords. And then
Okay.
I do have one more poll I'll launch while we're still speaking, and it's just asking you to rate today's session. Also, I don't know if it was addressed or not, the Chevron doctrine question. Did you get to that one earlier?
I did. Let me talk a little
Okay.
bit about next week's the fourth part of the protest series. So next week, same time, we'll be talking about OTA protests and other things that are not regular procurement protests. That's a really great topic and very timely, because there's been 2 recent decisions coming out of the Court of Federal Claims that kind of shaped this, and we have 2 judges of the Court of Federal Claims reaching kind of opposing or conflicting conclusions about that. And so this, tons and tons, billions and hundreds of billions of dollars are being spent through other transaction agreements, OTAs, things that are by definition not procurement contracts. And we have the Raytheon case from Judge Bonilla, and the other case, the name of which I always forget, by Judge Hertling. These 2 decisions come to different conclusions about whether you can and must go to the Court of Federal Claims if you have a protest of an OTA. So that's one of the things we'll be talking about next week, as well as other things like state procurements or BAAs or commercial solutions openings. So see you next week to talk about that. There is a question here, which I'll be happy to answer while we still have time, but this is sort of the end of the presentation. Is there a possibility that a new procurement system and process undergoes a comprehensive corrective action that would establish responsive? This is, again, difficult for me to answer kind of on the fly here. There certainly is the possibility right now of significant procurement reform. One of the things that is happening is a rewriting of the FAR. When you rewrite the FAR, you're taking things which are binding regulation, because the FAR is a binding regulation on agencies, and you're moving them into policy. You're making them agency policy. So every part of the FAR that gets moved from the FAR to these agency policies. The question becomes whether you can actually make those bid protest issues, because the case law is pretty clear that agency policies are not binding on them and are not the basis, cannot be the basis of bid protest. The trickier question is, all those things that used to be in FAR, they were binding regulation. Is their movement to a policy, in fact, appropriate? Is that justified? Is that legal, to use a simple term? So that's a question that we'll be facing in the years ahead. Thanks so much.
Thank you for joining us for today's session with Jeff. And Jeff, thank you for putting together today's presentation. We hope you all found it insightful and informative. Just a reminder, a recording of you got a little applause there, I don't know if you saw, a recording and your certificate of completion will be emailed to you within 2 business days. So you can rewatch that for anything you may have missed. And to access any certificates and any other from the series, please complete the password survey on the PCI website under My Certificate and Courses. If you've missed a password, feel free to reach out. If you have questions about certificates or passwords, you can email Josh Pina, JOSHPINA @publiccontractinginstitute.com. And don't forget to join us next week for part 4 of the series, Can I Protest OTAs, BAAs, CRADAs, etc. A very long title, but it'll be the finale of this series on Wednesday, July 17th, same time, 10 to 11:30. And yeah, thanks again, everyone, for being here. And we look forward to seeing you next week. And
Thanks.
let me see. Yeah, any other questions? I'll make sure to address after this. But anything else you wanted to say, Jeff, before we log off?
No, thanks for paying attention.
All right. Have a great rest of your day, everybody.